Yes, welcome to the No State Project live on my YouTube channel for June 3rd, 2018. Yes, June 3rd, 2018. I'm hoping we're streaming. Okay, welcome back. We're going to try this again here live on the No State Project on my YouTube channel, of course. It's June 13th, 2018, live from the fortified compound in Mesa, Arizona. Hopefully it looks a little better, but hey, you don't need to see me so much, but it is episode 68 already of the big broadcast show. And what we do here, for those who are new, just tuning into the broadcast, Anarchy. It's an extra hour of Anarchy radio, in addition to my regular 3-hour broadcast on Saturday, which I will be live and streaming in HD. Yeah, we'll see what we can do about straightening out the OBS. Anyway, Anarchy, that is an absence of rulers, not an absence of rules. What we like to see, what we would like, I think everybody would like to see, that the rules apply to everyone across the board, that the principle of do no harm, live honestly, injure no one, give every man his due, applies to everybody, and that there aren't a select few in society that get to violate those basic principles of right and wrong, and especially if they're called the government. So the Daniel Shaver shooting, which was horrific here in Mesa, Arizona, the cop got away with it. And if you see the video, it's absolutely it is nightmare-inducing. It's bad. So the rules don't apply. So even when the cops are charged for blatantly killing somebody, even if it's not murder, if it's just negligence, they still get away with it because the rules don't apply to them. It's all for show. When they put them on trial, it's just for a show. It's disgusting. So we want to get to a voluntary society where everybody is actually equal as far as that the rules apply to everybody. There are those among us who think that government, people call government, and government doesn't even exist. It's just men and women forcing us to give them money. That's really all they are. And some people think that they're special, that the rules don't and should not apply to them because they're government. There's no other logical reason for it. There is no logical reason for it. There is no coherent argument. Well, the rules can't apply to them because there is no argument. There is no actual argument. So that's why we talk about anarchy, getting to a voluntary society. And one of the ways we do that is by challenging these people, educating people, because, look, it's very difficult for people to understand that, hey, what they think is real is just a public relations scheme. I know. I went through it myself. But when they actually go and talk to these people themselves, if they go into court, which always sucks, or they go into a city council meeting, or they just talk to friends and they start talking to them and asking them questions. Why do you believe what you believe? Why do you believe that their government and that the rules don't apply and that they're more than just men and women forcing us to pay them? So, ask them and go in front of city council meetings, because it'd be very difficult to get people to stop complying with them and actually want to have a voluntary society if they think they're already in one. But when they see the evidence for themselves that it's actually a criminal organization that is providing services like water, sanitation, and whatnot, then maybe they'll cross over and actually, start to do something to correct that and change society. But too few of us actually understand and accept those facts. They are just men and women forcing us to pay them. And then we bring this into court. So if you go to markstevens.net, I had the banner up during the broadcast. But if you go to markstevens.net, you'll see we've got plenty of success stories. Plenty of times where we've had success in court. I apologize. I was out of town. I did not have the opportunity to post the 2 success stories. One is in Florida, and the other one is in California, where I believe the demur was sustained. I don't have much of a docket information on that, but I will post what I have in a video. But I do have an order from the court in Florida. And so what I was told was that the police officer decided he shouldn't have given the ticket in the first place and withdrew, which was pretty nice of the cop to do the right thing. I don't think they're going to go and try to get him charged with filing a false claim, but because that's not what happens. Even when police officers are proven to lie on the stand, they don't get charged with perjury. No, they go after people like Martha Stewart. Oh, but police are able to lie to prosecutors and get away with it. Yes, the slaves love their masters. Just can't put enough praise on them. Well, it's the government. Well, it's the law. So let's bring up, we have area code 360. You're live on the No State Project. What's your name? Where are you calling from?
Hi, my name is Ryan Pruitt, calling from Washington State.
Ryan, what can I do for you today?
All right, so yeah, we've had a lot of success due to your material and motions to dismiss in California. Now we're in Washington, and we got another case against us, and so it's actually an alleged DUI case. And right now we send in some motions to dismiss, Brady, discovery, and just got a couple questions for you.
All right, shoot.
All right, so I'm wondering, so I just got the prosecution's discovery, which there's not much there. They're asking that, they want me to respond to it. How do you go about that?
What did they actually give you as far as discovery?
They gave me, it's a lot of pages. None of it's actually so we bring up issues of jurisdiction and stuff. They haven't responded yet to that motion.
Okay, wait. We'll talk about the motion in just a second. How did the prosecutor respond to the motion, to the discovery request?
We got the officer's probable cause report, and then we got response and demand for discovery, and they sent some pictures and stuff like that. And then they're asking that they're requesting that I respond with material and information required under the CRRLJ 4.7 and basically defendant's obligations.
They want you to give them discovery?
Yeah.
Are you planning on presenting any evidence?
No. I mean, we're waiting to hear from their evidence, and then we go from there.
Yeah, if you're not planning on putting on a defense, and you're not planning on calling witnesses and entering any evidence, then you're not required to give the prosecution anything because you're not presenting anything.
That's what I thought. Okay, so, I'll wait till they, laughably provide evidence establishing jurisdiction, and then, which will never happen, and then we'll go from there, but, okay.
Well, you still, what I would do is respond to them, and I would say, well, I'm not planning on putting on a defense. But your discovery request is not sufficient here. Do you have a witness with personal firsthand knowledge that's going to be testifying that the laws apply and you violated them?
Right. So so we had an arraignment, which is actually, I've been listening to your show for probably like 10 years, and I've had a lot of success between me and my brother. We got 28 cases thrown out, either dismissed in the interest of justice by the judge or thrown out by the prosecution in California. Lack of evidence. Yeah, lack of evidence for establishing jurisdiction.
Jeez, what are you guys doing there? You're getting 28 charges.
So we're just growing some plants.
Oh.
You know how they like to rack up those charges, so. Really just interacting with the public voluntarily, but happen to have too much plant material in the car.
Got it.
And at this point, the police became violent and attempted to subdue my brother. They beat me up pretty well, actually. you know, the guy, he got so mad. You know, I was just, you know, I was asking him if yeah, I asked him for due process of law. He told me to place my hands behind my back. I'm like, whoa, hold on. Do you have
but
due process of law?
Ryan, why are you asking the police officer questions? Haven't we mentioned this many times on the show? You're not supposed to be talking to the police officer. You cannot talk your way out of a ticket.
Yeah, you know, it was one of those. I was a little bit intoxicated, you know, and but I was trying to, you know, I tried to just calm the guy down because he was getting really violent, and he wanted to arrest me, and I know, yeah, there's probably a better way I could have went about it, but so when I asked him if he had due process of law, he came at me with a flying knee, and so I dodged it, and then I'm like talking to him like, whoa, calm down, hold on. And then he grabs me, starts choking me from behind my back, punching me in my face, ends up getting me on the ground, rubbing my face in the gravel, saying stop resisting. I'm just trying to keep my head from being scraped up on the gravel. And then he picks me up, tries to break my arms, pick me up after I'm handcuffed, tries to throw me on the hood of his car, and I'm like resisting my head being smashed on the car. Then he takes me and busts his little spotlight mirror, but he breaks his spotlight mirror with my face. And anyway, we had that dismissed, but from a prosecution. And yeah, so I mean, but
wow, and that was in California. They did that.
Yeah, California.
Clear Lake, California.
Oh my gosh, you know, I'm spending a lot more time in California this month. I just got back last night, and I got to go back Saturday night after the show. And that is what town or city did this happen in California? I want to know to avoid that.
Yeah, it was Clear Lake, California. The
yeah, but where? Where in California?
Go ahead.
Where in California? What city?
Yeah, it's Clear Lake, California. That's Lake County.
Oh, Clear Lake. Jeez.
Yeah, and the officer's name is Aaron Clark. His badge number is 204. And what I heard, I have a friend. He's a bouncer at a casino, and what I've heard is this guy, he likes to fight. He likes to escalate things towards violence.
This is why we say we don't talk to 5-year-olds with a gun, because how do they respond? Like a 5-year-old, right?
Like a 5-year-old. Yeah, you're exactly right. Hey, and so, you know, I've been, you know, I went to law school. I used to live in Hawaii, and I went to Richardson University. I didn't graduate or anything, and I ended up getting into some things, and I found out about you and your the way your strategies, your method. It seemed to work well. It just makes a lot of sense to me. And, you know, I'm totally anarchist and voluntarist in that sense. And so, you know, following all your material, I seen, so my brother, you know, I got him on board years later. I've spent a lot of time listening and practicing your work. And so my brother, he's got a case right now, though. And,
okay, well, let's address this one, because now you've got the discovery request. So I would respond to the discovery request and let them know that they have not provided all the Brady material. So is the witness they rely on qualified or not? Do they have personal knowledge that the laws apply and you violated it, since that's what they're going to be testifying to?
Right, okay, yeah. So incomplete discovery, okay.
Yeah, it's Brady material, because if they don't have the personal knowledge, then that has to be disclosed. That's Brady material, right, because you can use that to impeach their witness.
Yeah, right. All right, yeah, and I was already planning for impeachment. I know what's going to happen. I'm hoping, actually, you know, in California, we had every case was thrown out before. I mean, we didn't even get past arraignment.
Damn, you're doing. I'd like to see some documentation. So if you can get the copy of the docket to show that, I'd love to be able to post that. That's quite a record you got going there.
I'll do that. I'll do that for you and everybody else listening. Yeah. So you know, another thing so my brother, man, he's okay. He's pretty knowledgeable in this whole thing, but he doesn't seem so confident in court, and he lets the judge slide all the time when the judge just tries to make him seem like an idiot or something like that. And I don't want that to happen. I normally I'm the guy in court, or I just send in the motions and it gets dismissed without him having to say much. With this one, they didn't throw it out at arraignment. So what I'm wondering is, I would like to actually talk on his behalf. I'm not a licensed attorney, like I said. I went to law school. I didn't graduate though. I dropped out. For good reason. I couldn't. What they were having me do is going through mock trials and arguing the same case with the same facts alleged, everything the same, as both the defense and the prosecution.
Yeah, that's pretty standard.
I thought it was that's crazy. Is all you do, like, you're representing a case that you don't necessarily believe in.
Well, what they're doing is, as far as my understanding it, they're trying to teach you how to argue effectively, so that you don't necessarily have to agree with it. It's one thing when you're in college when you're doing that, because it's just an exercise in how to argue and how to speak well and to make a valid case. It's another thing when you've got in the real life where attorneys have to do that. Some of them are public defenders, and they know it's their job. They have to defend someone they believe is guilty. But then you got to look at, can he believe that so and so is guilty and still provide him a valid, effective defense? So I'm not so keen on that. I don't think so. But as far as law school, I don't see the problem with doing that. It's just an exercise in teaching you how to argue, and it really does help though. I think it's very important that we do understand the opponent's side. We do understand the other side's argument, because frankly, if you don't understand the other side's argument, this is why I ask so many clarifying questions, because I want to make sure I'm actually addressing the other guy's argument and I understand it, because the better I understand it, then the better that I can debunk it if possible.
Right, yeah. And that's why I love your messages. They think they could use little, sneaky words and avoid the be unresponsive, avoid actually answering the question, and that, and thinking that that's going to get them around it, and then you bring them back. Whoa, hold on, I asked you a question, I expect a response. And that's being specific. I love that part of your message. But so one of the things that I'm wondering just how the hell you did it is in Ian Freeman's hearing, DMV hearing. How were you able to talk on his behalf?
Well, I've done it a number of times in New Hampshire by video, and unfortunately, one of them I was not able to post. Because it was administrative. It wasn't in court. And you're not, look, I don't think they're going to be as violent if you're trying to do it in Washington. As California, the hand goes to the gun immediately. They are ready to shoot you, these animals in California. And I've been there, but I've tried. I would say you much better just trying to converse with him and confer with your brother. And your brother does all the speaking, because I don't think there's any chance that they're going to allow you to do that. So your brother's going to have to prep just as much as just like you. And you can and if they allow it, they may allow you to sit there and confer with him, but not to make objections and make argument and question witnesses. I've done that many times, but it's usually not in court. I've done it in court. I have. Let's say out of 10 times, I've done it one time out of 10. The rest of the time, I am just conferring with the person I'm helping.
So, have you been able to? I know you like to avoid the courtroom, fear of being jailed for so-called contempt of court. But okay. So, say I had my brother doing all that. What if I sat next to him? I was able to pass some paperwork and whisper into his ear certain things. Would that be a thing? Well,
that's what I meant by conferring. I've done that many, many, many times. That's the overwhelming number of times that I've helped people in court where I've spoken at all. It was because I was conferring just with them. And so the judges will say, well, it's okay if you want to confer with him, but don't interrupt the proceedings and do not address me or the attorney. And it's usually fine. So that you would still want your brother to, to definitely do the role playing and prep, because he's still going to have to talk. You're not there. They're not going to. I mean, you got a hell of a track record there in California. I don't think that's I don't think they're going to care, even if you brought it up. Just bank on you're not going to be able to speak, and your brother's going to have to defend himself, and he may be able to do it with you conferring with him.
And so how do you go about that? Is it just like an informal request right there? Do you give them advance notice that you plan to, have somebody there, conferring with you?
I usually just do it when I get there, that the judge will ask who you are and what you're doing there, and you say, well, this is my brother, and I want to help him by just conferring with him. I have no intention of speaking to you, or anybody else, just quietly to my brother without interrupting.
Okay. That's simple. All right.
The judge might be cool with it, and he might just restate again, don't you dare interrupt. But I would say there's a better chance than not that the judge is going to ask you to sit behind the bar.
Okay. Yeah, we're going to go ahead and try that. I mean, I'm hoping that with this motion to dismiss, it's your motion to dismiss. I added some things. Actually, if I could, I'll just send you my motion to dismiss, and you go over and tell me if I messed up in any way. I mean, it's based on your motion to dismiss. And another thing, would you be how you spoke on at Ian Freeman's
Ian
Freeman's, yeah, right. When you spoke there, like, is there any possibility that could happen here with our case right now?
You're not in an administrative proceeding, and they're probably not going to do it by video. Now, your brother might be able to get it telephonically, and then this way, I've done it where it was telephonic, and yeah, they're set up for that. I mean, it is 2018. Hell, if I can broadcast from my fortified compound in Mesa, Arizona in glorious HD, you can do a phone call to a court, So this way, if he's able to get it telephonically, which is very rare, unfortunately, then yeah, you would be able to assist him. So what I've done is where I'm on Skype and they have the court on speaker and I can hear everything. And so he's got me on a headset and nobody's able to hear me except for like you, whoever I'm helping. So that's a way to do it. But I again, doing it telephonically, they hate to do that. And I would say that your chances of having it done are pretty damn slim, if not zero. And the only real way that you could improve your chances of getting that is if your brother's disabled in some way.
He doesn't speak Latin, does that?
I don't think you need to speak Latin to go to court.
Yeah. Well, if they're going to use a dead language, maybe. But,
well, yeah. They use a dead language because it's supposed to be for precision, and it's not. It's supposed to be so that things aren't being constantly redefined, so that when you go in there, proper means proper. In your proper person. It means the same thing today that it did in Caesar's time, but it doesn't work out that way. I have heard them use very, very, very little Latin in court. Very little in limine, pro per or pro se. So
when you say so for instance, pro se, like a pro se litigant, self-representing, do you have any objection to that? I'm sure you've heard the sui juris.
Yeah, I don't give a damn. To me, I don't make a distinction. They're going to hold me to the same standards either way. I'm pro per or pro se. To me, it's a distinction there is no real distinction. You're defending yourself. You're not. I would always say that I'm not representing myself. I'm defending myself under threat, duress, and coercion from this attack. But I'm certainly not representing myself. So I got a ton of calls lined up. So I got to let you go. Let me know what the prosecutor says in response to your follow-up for the actual Brady material. And if he doesn't give it to you, then you should get it comes with the templates, the motion in limine, which limits his arguments because he doesn't have the evidence, and also motion to dismiss for prosecutorial misconduct because he is knowingly putting a witness on a stand that lacks personal knowledge, and he's arguing without evidence.
All right, will do. Yeah, taking that down now. And all right, Mark. Hey, I just want to thank you for everything. You know, I could be behind bars now, but you know what? You've got me on a lot of stuff, and those our California cases between me and my brother. We're not talking 28 cases. We're talking 28 counts and maybe 5 or 6, 7 cases.
Okay.
I'm gonna get those to you so you can post them too.
I appreciate it. Thank you very much. Appreciate the call. Ryan in Washington, formerly of California, who being behind bars is considering you could be dead. That cop, this AA Ron Clark, could have killed you. And if what Ryan is saying is true, he's very lucky. AA Ron, this crazed police officer, didn't kill him. Dang. That's why we don't talk to the police. Don't talk to the police. If you are stopped, all you should be doing is giving the license and registration, which is always under threat, duress, and coercion, which Eric, was saying that the driver's license is voluntary. No. Getting a driver's license is not voluntary. It is compulsory. You do it to avoid going to jail and maybe being killed on the side of the street like Ryan could have been killed. So any charges that taxes, which includes a driver's license. Yes, vehicle license tax, driver's license tax. They are taxes. Any arguments that paying taxes is voluntary is wrong. And anyone spouting that crap is wrong. Look at the facts. The facts dictate and support the claim. It's remarkable that in this day and age, but then again, I have Robert Jones, IRS supervisor, trying to make the argument because he knows that he already admitted he had no evidence. Then he said he didn't need evidence. Then he said that due process didn't require evidence and that he could act in good faith without evidence. With all that, now he's trying to make it look like he's still trying to make it look like he's the good guy because, you follow all the questions because that's ridiculous. And he's actually arguing, claiming that no one is forced to pay taxes, that payment of taxes is voluntary. Well, anybody can look up the IRS manual or the publication for frivolous arguments. Just do a search, IRS frivolous tax arguments. Go down there. You'll actually find in there, unlike issues of fact, you will find that the argument that taxation and payment of taxes and filing a return is voluntary is in fact frivolous, because it is. It has no merit because you either pay or you go to jail. The fact that there's a tax evasion statute, you see? The fact that they have statutes that if you drive without a license, it's a misdemeanor. It's a crime. Not voluntary. Not voluntary. We've got Jeremy in Wyoming. Welcome back.
Hello.
Hello, Jeremy. What do you got for us today? Good news?
Yeah, I got some damage control on that criminal case that I had. He called my bluff, prosecutor called my bluff all the way up until the pre-trial conference. Then he came, as a nice guy. He's never even looked at me. And he came at me and said, you want to work on a deal? I was like, well, what do you say? And, talked for a few minutes. And he's like, probably get it out for $100. And with the way it was looking at with missing court and whatnot, I just saw that as good damage control and just called it good.
Cool. What were you? What kind of fine were you looking at before?
It was $700 maximum for the disorderly conduct, or not disorderly conduct. I'm sorry, simple assault, and then there was what was the other one? Evading the peace officer or something like that. So that was, the other one was like 300, but either way, I knew they would have gone for my throat on both of them. So $100 is phenomenal price.
So you were looking at possibly anywhere between $500 and $1,000 with the two charges.
Right, correct.
100. Okay, well, hey, we got to take that.
Exactly, and I'm working on my next one, which is a speeding ticket for a municipal court here in Sheridan, Wyoming.
You got
I'm
enough.
excited to get that one started.
What do you got? Something going on with Ryan?
What?
I was like, you got something going with Ryan? He had 28 charges between him and his brother.
Yeah, I got kind of pissed when I saw that, so I want to get up there with him. No, but yeah, one interesting thing I was told by the prosecutor there when I was asking him, you know, what he was talking about, what he wanted to do and stuff, he said, because I told him, like, well, I want to just go forward and challenge jurisdiction. He's like, well, I don't know why you're going to waste your time. And obviously, he's just lying on his ass, but he's saying, you know that when you walk into that courtroom, they have jurisdiction over you. I'm like, and I was, can you cite that? And he's like, well, no, you can look it up in the library. I'm like, yeah, you dumbass. You know, but he's saying, oh, it's back in the Western days. Somebody could come and kidnap you from Montana, say, if you had a bailout or whatever, and bring you back to the courtroom. And when you walk into the courtroom, whether it's in shackles or free, your jurisdiction has been, you know, proven. I was like, what the heck? You know, and I was just so blown away. But I didn't really care. I wasn't going to waste my time arguing because we weren't even in the courtroom or anything.
Not true, but you could have, some better follow-up questions would have been, so if I never come into the court acquires no jurisdiction. It's all based on my physical location.
Right, yeah, I should have went with that.
But you're still, like, you know, you're still used, it's still the same thing that if you're physically in Wyoming, their rules apply. So you can still add, well, could you please explain exactly how, you know, why do you believe it's true? How does my physical presence, whether it's compulsory or not, in Wyoming prove your Constitution applies to me? Could you offer me some explanation, either now or when we put your witness on the stand? Either way is fine. But why don't we take care of that right now?
Yeah, it blew my mind, though. I don't know. I really should go try to look that up and see. I mean, it almost seems like a wild goose chase.
What's there to look up, though? Look, all you want to do is get him, whether it says that or not, is irrelevant because it still hinges on the same claim that if you're physically in Wyoming, the laws apply, right? Isn't that it? So if you look it up and that's what it says, that still depends on whether the laws apply because you're physically in Wyoming. So it doesn't matter about looking it up. So what I urge you and others to do, when somebody makes such a wild claim like that, and that is just off the charts stupid, ask them politely, why do you think that that's true? Why do you believe that just because I'm physically in Wyoming, your laws apply to me? Could you please explain that to me? That is going to be a 1,000 times more effective than saying, can you cite it? Cite it. It's like saying, can you show me the law that imposes an income tax on wages?
Okay, well, I'm going to give him a call and talk to him about that, and I'll have it recorded or not, so we can send it to you, you know.
Okay, yeah, that's cool. Just keep that in mind. Whenever somebody is making a claim, no matter how hardcore or stupid or unorthodox it may be, let's see first if I understand you correctly. You could bring me in here violently and the laws still apply. Wow. Okay. So the basis of your claim is if I'm physically in Wyoming, your laws apply, right? Got it. Okay, great. Once he's agreed to that, you got to start deconstructing that. You want to know why he believes that this is true. He's prosecuting you. So he has to have proof. He has to be able to explain, even in court. You know, that's what a cross-examination and what a closing and opening argument's about. He has to make his case beyond a reasonable doubt or by a preponderance of the evidence. So he has to be able to explain, why does your physical presence prove a written instrument called the Constitution applies to you and creates obligations? How does that work? That's why
Works perfect for me, and I'm excited.
Well, just walk them through that. It's no different than any other claim. it doesn't matter what the actual claim is. We're always going to go through and confirm that that's what the claim is, so we understand that that's what they believe. And we want to know why they believe that that's true. What led them to believe that that's true? So basically, reconstruct your argument for me, sir. Why is this true? Because remember, for you and everyone else who's listening, if the prosecutor cannot make his case, you don't have a burden of proof. All you have to do is show that they can't make their case. That's all we have to do, is to say, you remember My Cousin Vinny? Did you ever see that movie?
Mm-hmm.
The opening statement, the prosecutor gives the opening statement, and Vinny walks up and says, everything that guy just said was bull. See, that's all we really have to do. I'm not saying say that exact, but we have to just point out the prosecution doesn't have any evidence. The prosecutor is making an argument he knows he can't support. So if you do speak to him prior to going into court, you'll be able to write down his words. He may say something to you like prosecutors have said to me. So when you ask him point blank, exactly how does my physical presence prove the Constitution applies to me? And he says, it just does, or that's the way it works. I got to write that down. It just does. Are you planning on using that in your opening statement? Are you going to bring that out on direct examination with your witness?
The judge would just go, you're right on that one.
Well, the judge could say, that's just how it works. Like, really? Well, let's just see what the witness has to say about that. And again, the witness, as you know, made these determinations prior, and that's what the ticket is based on. That the laws apply, you violated them, and he had jurisdiction to write you the ticket, and he had probable cause, blah, 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 blah. So how he supports that position, how he came up and made that determination, is relevant on cross-examination, and the prosecutor is required to have evidence to support that. How did he determine probable cause? Anyone tells you that how the cop determined probable cause is not relevant on cross-examination or pretrial, that's just not true. And the rule generally is 602 at the federal level, and in Arizona, it's 702 in California. It's probably 602. They adopted the federal rules there in Wyoming. It's the same thing. But bottom line, whatever the number rule is, they have to have personal knowledge of the matters they're testifying to. And again, the police officer is testifying to what? You violated the law. That he saw you, determined the law is applied, and now you violated them. So he has that personal knowledge. So remember this basic premise of the why and how questions, and ask them as leading questions. The why and how are going to be really, really effective and powerful against these people when they start talking about these claims that only exist in their head. They're literally just arguments. There's no substance to them at all.
Yeah, that's the way I'm starting to see it more and more every single time I, even think about it. Even listening to your shows helps so very much. But it's exactly true. It's just something they pretty much made up, and they're establishing it as right. And
yeah, they're actually saying to this prosecutor is actually telling you that they can commit a crime. They can violently bring you in there. In fact, there is actually a United States Supreme Court case that somebody likes to throw out. I don't want to mention any names, and I just want to mention the argument that the Supreme Court of the United States says you could be literally kidnapped, and brought into that court. That as long as they physically bring you into the court gets jurisdiction. Really? Again, it begs the question, because the United States Supreme Court also said in Milliken versus Meyer and the international shoe that quoted it, that the taking of jurisdiction may not offend traditional notions of fair play and substantial justice. Now, if they are saying that they can literally kidnap you, but that doesn't offend traditional notions of fair play and substantial justice, holy crap, whose notions of justice and fair play are they talking about? Ted Bundy? Holy crap.
Yeah, that's pretty much what it's coming down to these days with that kind of stuff,
Yeah. So when they make these outrageous claims, well, when they make these claims, all we're going to do is sit back, make sure that we verify that that's what they're saying. You're really saying X equals Y. Yep. Okay. And then we start moving into the why and getting to the how. Why do you believe that that's true? Why do you believe that just because I'm physically in Arizona, your laws apply to me? Why do you believe that a police officer can get on the stand, say I broke the law, and I can't question him on that prior statement? That's it's a very simple concept, and it's just that the difficulty in putting it into practice is just withstanding all the verbal diarrhea that you're going to get from these prosecutors, these lawyers who don't want to answer a direct question with a yes or a no or give them the actual evidence. They would rather turn around and try to make you feel stupid and gaslight you and talk in circles and not actually answer the question. That's why I say,
Right.
if you want to see a master at this, Kellyanne Conway. It blows my mind that they even have this woman on there. That's one thing I have against CNN and these. One more thing I have against these major news outlets. After a year, after the first 4 or 5 interviews where she doesn't answer a question, you can't have the woman on anymore. And yet, to this day, every single day she's on major media. I don't get it.
Yeah, that's a hard one. Yeah, when I was talking to prosecutors too, and now I vaguely recall him actually saying, that's just the way it works. And, he had this nervous chuckle about it, and I'm like, because I think he could see it in my eyes, like I wanted to say something, but he was almost trying to convince me, but I already knew, and he already knew that I knew, that it was bogus what he was talking about. But
so your prosecutor actually made the statement when you're asking about evidence to support their claim, that's just the way it works?
No, about the jurisdiction, I'm sorry.
Okay, well...
no, this is funny. This is the funny part. I'm sorry to cut you off there. He gave me this paperwork to fill out, to sign, saying basically, this is what you're going to have to do, this is what I'm going to do, but this is on top of the criminal rules and procedure. I forget what it's called, brain fart, but it's just a stipulant, that's what it's called. It's just a basic things, you know what I'm talking about. But he said, oh, well, we can't talk until you sign that, and then I didn't sign it, so he's like, all right, well, he's not going to sign it, Your Honor, in a motion, so we're going to go through it, push, blah, blah, blah. And then he came up to me first at that pretrial conference last week and started talking words and stuff. I'm like, well, what happened to your stipulation rules? We couldn't talk without that being signed, Like, what the...
Wow. That's just, I've had that a number of times, and it's usually not in court like you did, it was not in front of the judge. That's just the way it works. Imagine a police officer being permitted. See, and that's why they don't let cops. That's the real reason why cops aren't allowed to answer these questions. Because if they said, well, that's what they told me in the academy. So you had no actual evidence. You're just doing what you were told.
Right.
Or they say, that's just the way it works. See, that's a common thing I get, Jeremy, when you start asking bureaucrats about evidence to support their claim that the laws apply because you're physically in Arizona or wherever. And instead of answering the question, what they say is, well, that's the way it works everywhere, sir. If you're in Virginia, the laws apply. I'm like, I didn't ask you about Virginia. I didn't ask you about how, how everything else is supposed to work. I'm asking you right now to support your claim. If you want to talk about the laws applying in Virginia, if I'm in Virginia, we'll get to that after if you want to make that stupid claim. So I've actually had, I can't remember, his name was Kevin. He was a lawyer in Ohio, and he read me the riot act that he was going to have me prosecuted for practicing law without a license. And I actually posted on, so if you look up the lawyer in Ohio named Kevin, gosh, I can't remember his name. And I had asked him, do you have any evidence whatsoever to support your claim that the laws of Ohio apply to me, especially since I'm physically in Arizona? They do apply. Yeah, but can you support your claim? Of course, he slammed the phone down. He wasn't able to. He didn't sit there and say, well, I'll just have a cop say it, and the cop doesn't have to testify to that. No, he just slammed the phone down. And I followed up. Oh, and guess what? He never filed a complaint against me for practicing law without a license. I've even had him in Canada say that they were going to file against me for practicing law without a license or something like that, interference with the process. And I said, you realize I'm in Phoenix, Arizona, or Mesa, Arizona. You really think that your laws apply to me and I'm actually in Phoenix? Yes, they do. And you'll be hearing from our attorneys. Okay. All right. Okay. All right. So yeah, I would put in writing that that's what the prosecution's position seems to be, and I would use that as the basis to dismiss for prosecutorial misconduct. The best they can do is say that's the way it works. They have no evidence and no valid argument.
Hey, Mark. So with that mandamus petition for a writ deal, I had handed in. I got that all going, and it was saying unmatured when I was checking on the public docket. Aside from all that,
wait a minute.
It does get.
Wait. Well, let's talk about this before I let you go. You filed it, and what was the basis of the petition for the writ of mandamus, and where did you file it?
I filed it for the Wyoming Supreme Court, and the basis was through just a motion to dismiss was the exhibit, and then the basis was just the judges against Judge Huntis there in the circuit court here in Sheridan. It's just because my motions weren't getting heard.
Because
I wasn't being responded.
What were you trying to compel the Supreme Court to order the trial judge to do?
Take judicial notice. Take judicial notice. Yes.
Oh, well, okay. Well, judicial notice is mandatory when they're given the, what were you asking them to take judicial notice of?
It was the jurisdiction of the case, wasn't it? Is that pretty much what I'm saying?
All right. There's an issue. The petition for writ of mandamus is to compel the judge to do a mandatory function of the office. Now, judicial notice is mandatory for adjudicative facts. In California, you can ask for judicial notice of court rulings and laws. So, for example, I've used it unsuccessfully because they said they wouldn't take jurisdiction. Where we're asking for judicial notice that corpus delicti requires evidence of injury, and so that is something that the Supreme Courts have held. The California Supreme Court has held that it's a ruling, not dicta, and they are not taking judicial notice of that, even though under the evidence code it's mandatory. So here, you're a little off base for the petition for the writ of mandamus. I would, if the judge is making such awful rulings and you want to be able to maintain a mandamus, first file a motion to recuse the judge. And then if he doesn't recuse himself or herself, then mandamus lies to correct that. Otherwise, no. It's very difficult to get a mandamus.
She didn't recuse herself. I handed that motion into her. That's what I'm saying. All those limine, everything wasn't responded to. So.
Okay. Well, if then you have to make that the basis of the petition for the writ of mandamus, and so the denial of the motion to recuse, that is reviewable by mandamus. So I got to run before I'm totally out of time, and I got one more caller that I'd like to get to. But let me know how it turns out, and congrats on the damage control.
Great, thanks.
Appreciate that. And I've said it from day one that we can't win in a general sense with these people. They are men and women forcing us to pay them. They are criminals. That's my evidence. You force strangers to give you money, criminal. And in a lot of these cases, it's going to be where the best option. We can always fight them on principle. It's not always the best thing to do, but we can. But in a lot of cases, the best thing to do is to just, after getting some leverage with the prosecutor, when they're saying things like, that's the way it works, then you can get a pretty good deal. So he was looking at near $1,000, walked away for $100. The prosecutor was very happy. So that's great. That's great. We're always glad to see that, because all this has to do when you're going to court, unless you are strictly doing it as an activist, what we're trying, and this is for most people, it's not. We're trying to limit the damage these people are trying to do to us. So yes, most of the time we still get tickets tossed out, they withdraw. I have 2 I'll get posted this week, 2 more. But a lot of times they'll play hardball because they know they've got a complicit judge. They know that they can have the police officer testify on cross-examination that he saw you broke the law. He's testifying yet probable cause. He's testifying the laws apply. He's testifying that they had probable cause and that there was jurisdiction. But the moment you ask for evidence on cross-examination, and you can object saying it calls for legal conclusion. Doesn't matter. It'll get denied. Then when you ask for the evidence to support those claims, that's when he's not qualified to testify anymore. So so when you've got that, when you're going up against things like that, when you're going up against these criminals where the rules do not apply to the prosecution, and they will lie about what we're doing, they'll lie about our questions, and they'll be sustained without any discussion. Knowing that, you have to take all that into account. If you're not doing this as an activist, as strictly on a matter of principle to expose these people as the criminals that they are, then yeah, in a situation like with Jeremy, if you're looking at $1,000 and you've hit the prosecutor pretty good with it, against his burden of proof, and he's saying things that's just the way it works, then yeah. They're probably pretty open to making a deal, which is what we want in a lot of these cases. Pressure the prosecution so that they'll throw you a smoke and deal. But yeah, damage control. That's, I applaud people who, look, whether you're doing it as an activist or you're doing it just for damage control, that you're not even an anarchist. You may agree that that's pretty rational, but maybe it's still an issue where you haven't gone all the way over, but you see it as an injustice and you want to fight them, or you just want to limit the amount of damage that these people want to do, these criminals. So here, that's another example where yeah, he's looking at anywhere between $500 and $1,000 in court costs. He walks away for $100. So yeah, we take that. We hate to do that, but it happens. It happens. So yeah, I someone's mentioning here, Mark, they knew your motion was a winning one. I think in this situation with Jeremy and a lot of other ones, I think it's safe to say that the prosecution knew that they were up against somebody who knew what they were talking about and was actually holding them to their burden of proof. So whether it legally isn't required, whether the judge requires the prosecution or not, is a different story. The fact is, the prosecutor, and I've done this many times myself, I got a lot of call chains with this. When I confront prosecutors, they're not able to make a case. They are not able to support their argument. You could think that I'm the worst person in the world. You can say that I have had no success in court, which is not true. But there's no denying the fact that when I get on the phone and I speak to these prosecutors directly, they cannot make a case. When I speak to tax agents, they cannot support their argument. Now, yeah, you'll find people on YouTube that think that they can do a better job. Well, I'm much smarter than the IRS, Mark, and you just luck out and only post a call. You're cherry picking the calls. You don't put the calls online where they trash you and actually make a case. That's not the case. It's not the case. So I'm saying when the prosecutors get with someone like me or someone who's applying the Socratic method and holding the prosecutor to their burden of proof outside of court, not in front of a judge who can help them out, a judge who has a prison system that can turn around and say, well, you don't have to prove that, Mr. Prosecutor. I'll bail you out. Congratulations to Jeremy on the damage control, and I'm skeptical. I want to see the 28 charges that have been thrown out in California. That would be great to see and get that posted. So before I go, just to summarize, I don't think that they're necessarily always agreeing that the motion has merit. I think they're too arrogant to do that. But when you get the prosecutor face to face, or you get him on the phone, and he doesn't have the protection of his partner in crime, the judge, when the judge or no one else can turn around and say, "Oh, you don't have to prove that." When the rubber meets the road, when it comes down to it, when you're going against them one-on-one, they cannot prove it. Yes, they have a prison system, and they have people that say that they don't have to, but damn it, they do not have the proof. This is why I recommend going to city council meetings, because they're at the city council, they're not pulling out, "Oh, let's call our lawyers. Let's see how we can spin this. Let's have the judge threaten contempt so we don't have to." No, they don't have that. They're in front of a room full of people, and they have to either put up or shut up. And I've said 1,000 times, and I'll keep saying it. This is why we go and do this, to confront them, so that you know when you go into that court, you know in advance that prosecutor under no circumstances can make his claim. He has to rely on the judge. He has to lie. When you ask for evidence to support the police officer's claim that the laws apply because you're physically in Arizona, you know he has to lie in an objection, and you know you're going to get evidence of a rigged game. Because you ask him before you go in there to make his case, prove that this is right, and I will plead guilty. Prove it. He can't. That's the way it works. I told you, I had Andrew Mora, lawyer with the Franchise Tax Board, told me the same thing. It's just the way it works. I could just imagine Tony Soprano. So, "Hey, buddy, tough guy over here. What are you talking about, paisan, a goomba over here? What the? That's the way it works. Kabish, you understand me here now? You got me? That's the way it works." And you know you got him. You know you can confidently go into court, and the least you're going to be able to do is show how grossly unfair the prosecution is, that it was a rigged game from the start, that you'll have proof of the judge colluding with the prosecutor. Remember your Socratic method, and we're keeping the burden of proof on the prosecution where it belongs. Why do you believe that that's true? How does that work? How does a written instrument apply to me just because I'm physically in Arizona? It doesn't. It's all based on a prison system run by a group of criminals. Anyway, this has been episode 68 of the No Stay Project, live from the Fortified Compound in Mesa, Arizona, commercial free. I will be back live on Saturday to do the broadcast. 3 more hours of Anarchy Radio right here on YouTube, and also on LRN.FM. So, hey, till next time, salud.